Hello, and welcome back to Emmy Law's YouTube channel, your go-to sources for valuable insights on legal matters. My name is May. I'm your host, founder, and principal lawyer of Emmy Law, and today we're going to be discussing commercial litigation and the Personal Property Securities Act, which is often referred to as the PPSA. In commercial litigation, the Personal Property Security Act plays a significant role, particularly in disputes involving secured transactions. The PPSA is a law that governs the creation, registration, and enforcement of security interests in personal property. Before we get started, I'm going to let you know that I will be going between Personal Property Security Act, the full name, or referring to the PPSA. It's the same thing. Okay, just so that there's no confusion. Okay, the Personal Property Security Act is a crucial legislation in Canada that governs the creation, registration, and enforcement of security interests in personal property. A secured party can register a security interest on any type of collateral that is subject to be applicable PPSA in each province. Each province has its own PPSA, such as the Ontario PPSA, British Columbia PPSA, and Alberta PPSA. Here's a summary of how registration under the PPSA works in Ontario, British Columbia, and Alberta. To register a security interest under the Ontario PPSA, a financing statement must be completed and filed with the Personal Property Registry, often referred as PPR in Ontario in electronic form. The registration is effected during the registration period, which can be perpetual or for a specified period of years. A financing statement can be filed before or after the execution of the related security agreement. A single financing statement can cover security interests created in one or more security agreements. Registration can be renewed or amended as needed. In British Columbia, the PPSA is conducted this way. To register security interests under the British Columbia PPSA, a financing statement must be completed and filed with the British Columbia Personal Property Registry. Again, it's British Columbia PPR. Okay? The registration is effective for the period of time indicated on the financing statement. Registrations can be renewed by registering a financing change statement before the registration expires. Also in British Columbia, registration must be discharged within 1 month after all obligations under the security agreement are performed, if the registration relates exclusively to security interests in commercial goods. In Alberta, the Personal Property Securities Act, or the PPSA, the way you need to register a security interest under that specific act in that province is by registering a financial statement must be completed and filed with the Alberta PPR. Okay, so the Alberta Personal Property Registry. The registration is effective for the period of time indicated on the financing statement. Registrations can be renewed by registering a financing change statement before the registration expires. Registration must be discharged within 1 month after all obligations under the security agreement are performed, if the registration relates exclusively to security interests in consumer goods. And here is how the PPSA relates to commercial litigation. The PPSA establishes the rules as stated for creating security interests in personal property. This includes requirements for a valid security agreement and the attachment of that security interest to the property. In cases where multiple creditors have competing claims to the same collateral, the PPSA establishes rules for determining the priority of those claim interests. This is important in commercial litigation involving insolvency or default. It also sets out the rights and obligations of secured parties and debtors in these situations. To protect their interests, secured parties must register their security interests on a public registry. Failure to do so can result in the loss of priority in the event of insolvency or default, leading to disputes that may require litigation to resolve. The PPSA also provides remedies for non-compliance with its provisions, including damages or for wrongful repossession or failure to register a security interest. In commercial litigation, disputes related to the PPSA often involve questions or priority, the validity of security interest, or the enforcement of the security agreements. Understanding the PPSA and its implications is essential for parties involved in secured transactions and can help prevent or resolve disputes through litigation. In all provinces, registration is one of the methods used to perfect a security interest under the PPSA. Perfection is crucial to ensure that the security interest is enforceable against third parties. For perfection to occur by registration, the security interest must have attached to the collateral. Perfection is often described as the highest measure of protection available to the security interest against competing interests. It is important for secured parties to understand the specific requirements and procedures under the applicable PPSA in order for it to properly register and maintain their security interests. Remember, today's information isn't legal advice. If you require personalized guidance, reach out to us by visiting our website, www.emilaw.ca. If you enjoyed this video and found it helpful, don't forget to hit the thumbs up and also subscribe to our channel. We put out legal content almost every week for you to gain some insight in the legal world and insight on different laws and so forth. We look forward to seeing you again in our next video. Until then, next time. See you. Take care. Sorry.